We previously met the Holderman heirs back in August in this case, and if you haven't watched it, I highly suggest you watch that first. This is a super complicated estate case, and Judge Ricky explained it incredibly well back then, and I also broke down the law and who everybody is, because there is a lot of players in this case. So this is an update to the case.
Court of Butler County, Kansas, case entitled, in the matter of the estate of Larry Franklin Holderman, deceased. It's case number 2022 PR 168. Trent Wetta appears as counsel for the personal representative of the estate. Doug Cranmer appears. Who are all of your clients at this stage, Mr. Cranmer?
I still represent Frank Bly and Terry Robertson, who goes by Esme Pearl.
All right. Mr. Mills, I take that you still represent Mandolin Holderman. Is that correct?
That's correct, Your Honor.
All right. And Ms. Williams, you're still representing Susan Davenport. Is that correct?
That is correct, Judge, and she is with me today.
All right. Mr. Wetta, I'm going to start with you. I did receive from you an order, which I think is submitted under Rule 170, that you drafted stemming from the August 22nd proceedings that we had. It appears to be consistent with the court's notes in all material respects. I'll just tell you just a brief summary of what I ruled on that date. The will can be upheld. Court will enforce the disinheritance clause, anti-lapse statute triggered. Mandolin Holderman and possibly Susan Davenport take from the parent beneficiaries named in the will, but Pearl's children, and I put 4 in parentheses, also received from the great-grandparents. Susan Davenport's familial heritage, a disputed issue to be determined. Status hearing set for October 30th at 4:00 p.m. to review Susan's heritage status and to schedule further trial on issue as is necessary. Trent Wetta to draft journal entry with proportions of the estate and the shares to be determined later. Now, Mr. Wetta's order appears to be consistent with my notes in all material respects. I'm a little curious why I don't have signatures from all the attorneys. What's the problem here, Mr. Wetta?
Your Honor, I submitted that order. I did also attempt to, I hope it came through in fax filing. I'm going to be honest. It's been since the very beginning of my career since I fax filed something, but I did submit alongside the Rule 170 notice objections that were put forth by Mr. Mills. I believe Ms. Williams also had a slight objection, but we addressed all of that in the second draft. All of those documents are there in front of you, just out of an abundance of making sure that the court had everything that was in front of it. But frankly, I believe the only outstanding objection was from Mr. Mills. And so I did submit that order, Rule 170, at that point for the court to determine today.
Okay, I know some of you are stubborn and didn't go back and watch the original. So real quick, Larry Holderman is right there on the second line over to the left. He's the one who was deceased. He left his entire estate to his parents up at the top, who are also deceased. And then the next people in line to inherit his estate would be his 3 brothers, who were also deceased. He didn't update his will, even though they died all before him. His 2 children, he specifically disinherited from his will. One of his children has 4 children. So the argument was, would the grandchildren inherit from his estate? And the answer was no. However, the grandchildren would be direct decedents, inheritance heirs from his parents who inherited from him. So the inheritance would jump over to the grandparents, then it would go down to their children, which there aren't any. Then it would go down to their children's children, which would be the 2 nieces and his 2 children, which were disinherited. Then their share would go down to the grandchildren. So the 2 nieces and the grandchildren. Well, the one niece, Mandolin, thinks she should get everything, and that's who Mr. Mills represents, and that's where this whole argument is coming from, is he is challenging everything because Mandolin thinks she should get the entire estate, which is valued at, I think, $750,000 last I checked.
Mr. Mills, the court's inclined to approve it in its current form. Your position on that?
Your Honor, the only thing that I wanted to make absolutely clear is that my objections to the portions of your decision that you made were clear. And I thought that it might be better to state something to the effect that you entered this order and that I objected thereto, so it'd be right in the order. All the other counsel believed that, hey, I'm worrying too much about that. It's already in the transcript or in the record, and so they feel, and they may be right, Your Honor. I just want to throw that out there, but out of an abundance of caution, I want to make sure that I'm not foregoing any objection by going along with the order as written. That's all it really is. I'm not accusing anybody of not trying to follow your order, Your Honor. I'm just trying to be very careful in my asserting my objection.
Well, your continuing objections are noted, but don't need to be chronicled in the journal entry stemming from August 22nd. I would agree with Mr. Wetta's position in that regard. The court will approve the order in its current form. That should be on file later today, counsel. And I'm going to ask the clerk's office that when they get the chance, they're a little bit overburdened at the moment, dealing with paper filings and the like. But when they can, I'll have the probate clerk mail a copy of this signed order to each of you at the address stated in the order. All right, with that done, I will move to the petition filed by Mr. Mills to deem request for admissions deemed admitted. It's relatively straightforward. Ms. Williams, I'm surprised that you didn't comply with the request for discovery in this case and didn't file a proper response within the time period allowed, at least according to Mr. Mills. Your explanation for that?
Your Honor, actually, I did. I sent my answers to him and I sent a notice to the court that I had so submitted those answers. I was never informed by Mr. Mills that he was still waiting for the answers. I sent to Ms. Stapleton today a copy of my email and my answers that show on October 16th. I sent them to Russell Mills by email. And the first notice I had that Mr. Mills didn't get them was today when I got the email from Mr. Mills. I didn't know there was a problem. Had I been informed, I would have endeavored to get him another copy or fix whatever the issue was. But no, sir, we answered and we got them and I sent them to him. I was not aware that Mr. Mills didn't get them. And I'm not sure why Mr. Mills didn't get them, because I mean, you will see from my email that it was addressed to Mr. Mills.
What date did you send it?
October 16th, Your Honor. That was a Monday.
Okay.
I think the due date fell on the weekend, so we
Yes.
got them out on Monday, but we
All right.
got them out timely and they were answered. I've resent them to Mr. Mills, like I said, and Mr. Mills had picked up the phone and let me know we could have cured this, but no, sir, we endeavored to answer these in a timely manner.
All right. Well, I'm curious, Ms. Williams, since it is relatively pertinent to the issue, primary issue we have left. How many of these proposed requests for admissions did your client deny?
Haven't counted, Your Honor. There were several that she put don't know on. She actually, well, she denied outright one, and there were several she put don't know on because she just simply didn't feel like she had the information. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, she put don't know because she wasn't positive of the answer one way or the other.
Okay, which one did she outright deny?
Number 7, they were asking about an adoption entitled matter of the person, their person of baby Cons, a minor. filed in 1968. If those records have been submitted to the court. And so she denied that one. That was confusing question.
All right, I think he's just asking whether the records from that adoption proceeding had been reviewed by you, Ms. Williams, but hadn't been filed as exhibits in the district court.
Yeah, if they're talking about her adoption, that is correct. Her adoption, I think the probate, I'd have to look. I think it may have been in 67, but it was confusing. But yes, I've reviewed those that file. That is true. So to the extent that that matters, yes, I have reviewed that file. I think we know that. I've talked about that before with the court. So yes.
Okay. All right.
Your Honor, could I respond?
Yes, Mr. Mills.
Well, Your Honor, the thing that I would like to point out, and I don't mean to argue with counsel, but as I recall, I had sent those out to her on like September the 15th, and she had 30 days to respond, and October the 16th would be past the 15 days.
Doesn't
So,
she get the benefit of the 30th day following on a weekend, Mr. Mills? I mean, I traditionally don't work Sundays. I doubt if you do, though there are times when all lawyers seem to be pressed into service on Sundays. But I think, doesn't the Kansas Rules of Civil Procedure contemplate still that if the final day of a period falls on a Saturday, Sunday, or legal holiday, it's the next business day in which they become due? And that's what she says she did. She sent them on that next business day, which would make them timely.
I see what you're saying. Okay. I didn't receive them, Your Honor. I wanted to tell you why I didn't receive them. I don't know, but I didn't. So if that's a problem with the email, it's a problem with the email. But the other thing I'd like to say is, Your Honor, I'm not sure that you can enter a I don't know answer to a request for reduction. You can deny it and say why you deny it, and then that's fair. But I don't think there's a basis to allege a don't know. And since that's the case, then all those should be deemed admitted, in my opinion.
Well, Your Honor, I would suggest then we call them denied then, because she was trying to give what she felt was an accurate answer to the request for admissions. They're certainly not admitted. So if we need to go back and do a supplemental response, we can and deny all of those, but we're not admitting them because she didn't feel like she had enough information to say for certain if they were yes or no. So,
which is a standard response under some limited circumstances. I suppose what's bothersome is that she did that with so many of these.
Well, you have to look at some of the questions. He's asking her things that she doesn't really know. I mean, no co-workers of John Kennan have ever appeared and stated that John Kennan spoke of having a daughter. She doesn't know if any co-workers have ever talked of him having a daughter. Mandolin Holderman never heard John Kennan speak of having a daughter. She doesn't know what Mandolin Holderman heard or didn't hear, except some of it's the questions asked.
Your Honor, if I could respond, the point of many of these requests for admissions is to determine what she knows regarding the answer. And if she doesn't know, then that means she's not going to be presenting any evidence in that regard, it appears to me. And if that's what they're saying, then I'm okay with those answers.
Begging the question, Mr. Mills, even if all of this were to be admitted, where would that leave us?
Well, that would leave us with a inability for which I don't think they have anyway, but would leave them with an inability to establish any basis for establishing the child to be, meaning Susan Holderman, to be a child of the deceased John Kennan. And that's because she cannot establish that he notoriously had, that there's any evidence to establish that he notoriously recognized the child as his. And
Well,
therefore cannot.
That is a pertinent point, Mr. Mills, and I think it may go toward whether there's any statutory presumption.
The Kansas statute regarding the presumption of paternity is mentioned quite a bit during this hearing, but it's not discussed enough that you can actually define it. So just to give you a brief overview, a man is presumed to be the father of a child if the man and the mother are married before the child's born, attempt to marry before or after the child's born, get married after the child's born, or the man acknowledges the paternity of the child in writing. The mother has the man's consent to put the name on the birth certificate. The man notoriously or in writing recognizes paternity of the child, including but not limited to a voluntary acknowledgement made in accordance with KSA 2012 supplement. Yeah. Genetic testing, but it has to have a probability of 97% or greater. And the man has a duty to support the child under the order of support, regardless of whether the man has ever been married to the mother or not. And that is what is listed in this statute. So the two things that they're relying on is genetic testing, hopefully not, or the man notoriously or in writing recognizes the paternity of the child. However, that's really hard. You got to find something that shows that, define notoriously, because the man's dead.
Of paternity here. It wouldn't appear to the court that there is.
Right.
I'm not sure that's ever even been asserted by Ms. Davenport, that there's one of the statutory presumptions of paternity which apply in this case. I think her position all along has simply been, I am a biological daughter.
Well, and
without any of the statutory presumptions being in place, shifting, I think, the burden of proving paternity to her, essentially through probably the one conclusive way to determine it, and that would be genetic testing.
well,
There's also some other proof that could be provided, but it wouldn't establish a statutory presumption, I don't think. Do you disagree, Ms. Williams?
Well, Your Honor, I'm wondering, I emailed my response to Mr. Mills' motion or petition to dismiss my client's claim with a proffer of proof. And once again, I emailed that to Mr. Mills, I emailed that to other counsel, and I sent a copy to Ms. Stapleton for your benefit. And I've mailed a copy to the court for filing. In that, we respond to Mr. Mills's petition, citing the case law that is relevant, and we proffer the proof of people who can come in and testify that Mr. Kennan identified himself as Susan Davenport's father. And so we have that information here. And once again, that was sent to Mr. Mills and to everyone else by email. And I guess I'd ask everyone if they got it. If not, I can resend it.
Mr. Wetter, did you receive this?
I did receive it and I have reviewed it, Your Honor.
Mr. Kramer, did you?
I received it, Your Honor.
Mr. Mills?
yes, I did, Your Honor.
Okay.
Okay. All right, Ms. Williams, what is what is the burden of proof here, the standard of proof that would apply to this?
The standard of proof, when you have an illegitimate child, basically comes, if you look at the cases that actually Mr. Mills also quotes in his motion to dismiss, Meyer v. Rogers and the matter of the state of Leicester case v. Dunlap. And it basically finds that a father can confer heirship or beneficiaryship for probate purposes on an illegitimate child by holding this person out as his child, and that recognition of his paternity being notorious. And so these are the two cases that basically tell us that that is the way that one of the ways, other than our DNA, possible DNA evidence, is to show that she would be a beneficiary. So basically, if Mr. Kennan held her out as his child, and that recognition was notorious, or in other words, well-known, then he can confer the heirship or the beneficiaryship onto her. And that is what those two cases say. And we basically are attempting to give a proper proof here, showing that not only did he make these statements, but everyone in this orbit accepted it. And we've got several statements by family members and people who have heard, and at least one friend of Miss Kathleen Cox, which was her mother, who heard these things and are familiar with those facts. We also included his headstone and his obituary, which I think once again goes to the notoriety of his acceptance of paternity. He never questioned it, never told anyone he questioned it. He told people he was her father. Everyone accepted this. It was notoriously known that he accepted that he was her father and accepted that paternity. So, Your Honor, I think just with that, we meet the burden of proof in our case law. Now, we're also working on that DNA, which would also show that she's a biological child. But Your Honor, I think that what we've submitted to the court is enough right here with this response to Mr. Mills.
I think Mr. Mills has also raised a statutory defense. I think he's alleging, I hope I'm paraphrasing this properly, that your client's simply out of time under Kansas paternity law, understanding that the Kansas paternity statutes were passed after virtually all of these cases that you've cited were promulgated from the courts. And so if we look at what the statute currently reads, that you can bring in action at any time to determine the existence of a father and child relationship, which is presumed. And if it's not presumed, until 3 years after the child reaches the age of majority. With all due respect, I think your client is more than 3 years past the age of majority.
Your Honor, I think that there are two different ways when you're talking about an illegitimate child who's been adopted by another family. Yes, if you had the paternity way where paternity was established, etc., that would be proof of his paternity. But you can also establish it by him notoriously holding her out as his child and that paternity being notoriously recognized. And so I believe there's actually two different ways. And so, no, I don't think my client is out of time. I don't think she has to go in and try to sue him to have some legal finding of paternity. I think that this, for probate purposes, is the other way that we can show it. Or a third way would be with DNA evidence. So no, I don't think she's out of time. I think it comes down is she a biological child, or has her beneficiaryship given to her by her father, notoriously recognizing her as his child? So I disagree wholeheartedly with that analysis, Judge. I don't think going under the paternity statute is the only way when it comes to a probate case like this with an illegitimate child adopted by another family.
Your Honor, could I respond?
You may do so, Mr. Mills.
Thank you, Your Honor. Your Honor, the case law that I have cited and that counsel has just referenced were cases where I believe that the presumption of paternity under 2208 existed. Okay, it doesn't here, and so I would assert that the court is correct in its analysis of just being too late. When you look at 59501, just the definition, it talks about what children can be deemed children. Okay, well, a child who is biological and has been recognized as a child, so like my children, I recognize them from birth. My name's on the birth certificate. There's no question that I'm saying they're my children. So they are my biological children. Posthumous child, she wasn't a posthumous child. and children whose parentage has been determined under the Kansas law, parentage law. Those are the ways that you can be determined to be a child of the deceased. And none of those fit here. But, Your Honor, just for the sake of argument, I would be willing to go through these cases and explain to the court that if the court, and I'll try and just cut to the chase, Your Honor, if the court would look at the case of Record versus Ellis, and I understand this is an old case, Your Honor, but I think it does help us. Okay, it's 97 Kansas 754. It's a 1916 case. How it helps in this regard, Your Honor, is counsel seems to be hanging her hat on this fact of the father notoriously recognizing the child as his child. And in that opinion, and I'm kind of working backwards here, if the court wants me to work forwards to the back, I will, but I think that this Record versus Ellis case really explains what the issue that she's bringing out, meaning counsel for Susan Davenport's bringing out. And at page 756 of that opinion, it specifically states what is meant by the requirement of the recognition must be general and notorious. That's the issue she just stated. And the Supreme Court back then explained for us what that meant. And what it said, and it did refer to a bunch of opinions from the state of Iowa, because back then I don't think the state of Kansas had really clearly addressed this issue, but they did in this case. And what they said was, and if the court will allow me just briefly read some of the decision, it says at page 757, the Supreme Court of Iowa, whose statute is identical with ours, has ruled that general means extensive, though not universal, and notorious is synonymous with open. It goes on to say, as defined by Webster, general means common to many, or the greatest number, widely spread, prevalent, extensive, though not universal. And notorious means generally known and talked of by the public, universally believed to be true, manifest to the world. It goes on and talks about yet another Iowa case. There are several Iowa cases that had interpreted this statute that was similar. And it says that there's a Watson versus Richardson Iowa case that it cites. And it says both of these words are used in the statute with the design of emphasizing the thought that the understanding of the father's recognition should be as extensive as the immediate community of his residence and within the common knowledge of the public. It goes on. Extensive, common to many, or the majority but not universal, not concealed, open, generally and commonly known or spoken of. Those are additional Iowa cases that the Kansas court is citing. And if you look at that opinion, you'll see that I'm reading it word for word. And this, Your Honor, frankly, kind of goes to counsel's side, which is the recognition required is not of heirship, but of sonship. This was a son in that case and not a daughter. It further, the court now in Record v. Ellis, our court, is saying the proof showed that the father frankly admitted the relationship when there was an occasion for him to speak and made no attempt to conceal the same, though it also appeared that there were many of his friends, relatives, and acquaintances who had no knowledge thereof. And if we look back at my request for admissions, Your Honor, you're going to see that that's exactly what we have here. In that case, the father visited the mother after the child was born. I'm talking about Record versus Ellis now, and actually sat on the bed and pulled the child in his arms and testified, or stated that this was his child. Now, going on in the Ellis opinion, it says, let's see.
Mr. Mills, if you back up a moment, the case cite on where the Iowa cases were cited defining notoriously or
Yes.
notorious.
Yes.
What's the cite for that?
The site, Your Honor, is
Yes.
it is I'm sorry, 97 Kansas 754. It's a 1916 case, but there are very few cases that define this. As a matter of fact, it's almost the only one I could find that specifically defined these words.
Ultimately, that may be helpful to the court, but I'm almost getting the impression, Mr. Mills, that you're making a closing argument following a trial in which Ms. Williams and her client have presented their evidence, and then you're trying to say it's insufficient to carry the day. I know that there's probably some incentive on behalf of your client to never let this go to court, but shouldn't she have the opportunity to prove that Mr. Kennan notoriously recognized paternity of the child?
Well, Your Honor, and I guess what I would submit to the court is, for the first time, I saw these affidavits that were submitted. But if you look at the affidavit, Your Honor, even the affidavit she submits, which appears to be the evidence she's wanting the court to look at to determine this issue of notoriety, even to try and get herself over the hump, they just don't make it as it relates to the legal definition that even if you believed everything to be true, it doesn't seem to me that you can get over this hump, because all of the affidavits that she obtained were not as required under the Record versus Ellis case. So I don't know what else she's going to be able to think she can bring to the table to establish this notoriety, but she didn't put it in any of these affidavits that, again, I just recently was able to see, and obviously didn't have any time to respond to, but I'm trying to do my best to let the court know what the law is, so the court can take a look at it. Now, these affidavits, Your Honor, I don't know if the court wants us to waste a bunch of time having a trial and have me cross-examine these witnesses to testify live. But I think if you don't get past the notoriety deal, you don't get past asking for a DNA sample. I mean, you've got to be able to show at least some foundation, evidentiary foundation that meets the statute, meets the case law, and it's not there. And again, I think the court was right in looking back at the paternity statute, because it's only when you have that presumption that you can even look at the paternity statute, and I mean,
well, but they have a right to prove that one of the statutory presumptions exists, do they not?
Well, and Your Honor, if you look, what I'm trying to tell the court is, if you look at the request for admissions, that even now some of them the court could look at and say, yeah, they're deemed admitted. But if you look at the affidavits, not that I'm saying that they should be considered evidence at this point, but if the court did consider them evidence at this point, they do not meet the burden of proof under the case law, to find this to be a child of Mr. Kennan. And so, Your Honor, I think she's just not meeting her burden, and it appears to me that she can't meet her burden, or she would have put much more into these affidavits. So,
Mr. Mills, are you representing to the court that there hasn't been any discussion of what the word notoriously means by our appellate courts for
just-
107 years?
Well, Your Honor,
'Cause
there,
I think you
there
cited a
is-
1916 definition.
Your Honor, I understand.
And
But-
Mr. Mills, I'm much more worried about what the legislature meant when they placed in the KSA 232208, which apparently wasn't passed before 1985, what they meant by notoriously, which may or may not be the same definition that was used in 1916.
Yeah, Your Honor, the one thing, and I'm kind of with you on what you're saying. There is a case, and I just found it before, so I haven't been able to review it very clearly. So I want to make sure that's up front, but I'm certainly willing to share that with the court. Let me see if I can find where I wrote the cite down. But there is a case called In Re Parentage of MF. That's 312 Kansas 322, a 2020 decision.
The
And
court
I
is somewhat
think-
familiar with that, Mr. Mills.
I'm sorry?
The court is somewhat familiar with that case.
Okay, so I wanted the court to be, aware of that. And I think that does go somewhat to, in fact, they talk about a timing element of the notorious representation or a writing showing that but as I understand it, that case is a little different in the facts because you had like a same-sex couple there. Now, whether that in and of itself affects the language of the statute or not, I'm not real certain because I'm just telling the court I haven't had the ability to look through that because I just found it today. So
Well,
tried
I think that the trial, this court was the trial court judge on that case, as I recall.
Oh, you may.
And there
very
was
well
a
be, Your Honor.
companion case that was decided at the same time where
Correct.
perhaps there was some more recent interpretation of the word notorious. I don't recall that being a specific point in the MF case, but I also note that the WL case that was issued at approximately the same time may have addressed it. So there may be some recent pronouncement from the court regarding what notorious means for purposes of the paternity statute. But be that as it may, I mean, there is perhaps another alternative here. This court could consider just exhuming Mr. Kennon's body. I presume it's buried somewhere and it wasn't cremated.
It's buried in Eureka, Judge, and he did have a traditional burial. So yes, that would be.
When did he pass away?
1996.
76?
96.
Oh,
96. Yeah.
27 years ago.
Yes. And Your Honor, I will
Has
tell you.
anybody looked into the costs or the procedures that would be involved in exhuming the body for purposes of DNA testing?
Yes, Your Honor. And let me back up just a minute also to tell you that we have submitted Miss Davenport's DNA and we had submitted one of her great uncles also. The great uncle DNA has not been tested yet, but we do believe that will give us a result. But also the exhumation would be about $5,000. It's in Eureka. I think that there'll have to be an order of the court, etc. But yes, I think we can get that done. And yes, we think that would be a good thing to do because we think that that's going to prove it. You know, I'm kind of perplexed by Mr. Mills's argument. The things that he is saying about what general and notorious means. We have affidavits of Mr. Kennon telling people this is his daughter. I don't know how much more you can have. Then he's telling several different people, this is my daughter, I'm her father. I know
Him acknowledging that in writing would be a statutory presumption creating event.
And at this point, we don't have it in writing. We have been looking. There were some letters. We're investigating as much as we can.
We lost a house fire.
Yeah, there was a house fire and we're afraid that they may have gone in the house fire, but we are looking for those. We have people who saw those letters, but unfortunately we haven't been able to find one of the remaining letters. So we're investigating as much as we can, but Your Honor, you also have to understand that I don't know how we reconcile the fact that an adopted child can adopt through his or her biological family, even though they may be adopted by another family. So there has to be more than one path, not just paternity, but this other path of being held out generally and notoriously being their child. So I think through DNA evidence and or the testimony of quite a few different people about how he held himself out as her father and how it was known by everyone and no one doubted it. This was the fact that we can prove that she should be a beneficiary of this estate.
Your Honor, I'd like to respond to that.
You may, Mr. Mills.
Thank you, Your Honor. The fact of the matter is I can go through the case law that counsel cites right now, if the court wants me to, and show the vast difference in what happened in the cases that she cites, and wherein the court in one of those cases found that the person was the child. In the other case, the court found that the person was not the child. But the facts are so different than what we're talking about. The other thing is that I think the court needs to be aware of all these statements that she's talking about. 4 of them do not even state that the deceased, Mr. Kennan, told them anything about the child as far as its birth or his paternity. The other ones are from Ms. Davenport's husband, her son, and her cousin, I believe, and maybe a sister-in-law. And they all supposedly stem from 1 week in the life of the deceased, Mr. Kennan, wherein supposedly he meets over at her house, meaning Susan Davenport's, and is purported to have made some statements. So 1 week out of 28 years, I think, after the child was born, supposedly establishes an open, obvious, notorious, all this other stuff that I say it does not, even if you adopt those statements as in some way accurate. But so, Your Honor, they don't even meet the burden.
Your Honor,
It's a situation, Your Honor, where you have the person who's here trying to get essentially an award of money from an estate, and what is she saying? My only proof is I say so, my husband says so, and my son says so, and my sister-in-law, and maybe one other person, and that's it. This doesn't meet the definition of notorious as set out in Ross.
Hasn't she been included in obituaries of the family as a daughter
yes,
of Mr.
Yes.
Kennan?
yes. And she's on his headstone too as his daughter, Judge. And it's a little more nuanced than what Mr. Mills is alleging.
Well, yeah.
If you want me to respond to that, I can. It's more nuanced than that. Basically, what he's referring to, several of his statements have to do with the fact that Mr. Kennan was when he had 2 weeks to live and he was released from prison. He spent those 2 weeks with his mother and with his daughter, Susan. And so some of these statements and these affidavits come from that time when he elected to spend the finite amount of time he had left on this earth with Susan Davenport, which you don't do unless that person is very close and very special to you. So yes, some of these statements are from then, but also statements are from prior to that, when the sister-in-law, the letters, the phone calls that she witnessed, and the affidavits that don't talk about specific statements made by John Kennan actually go to the notoriousness of his recognition of his paternity. So I think it is more nuanced than Mr. Mills is letting on. I also included copies of the front and back of Mr. Kennan's headstone, where she is listed as his daughter, and his obituary, which lists her as his daughter. So, Your Honor, I think Mr. Mills I think it's more nuanced than what he is talking about.
Who provided the information for the obituary?
His mother, Mr. Kennan's mother, my client's grandmother. And we
How
also
did
have, we've talked about that before. Clara Lodema Holderman, who was one of the original beneficiaries. And I think we had talked about that in an earlier hearing. And also I know that there are pictures, we didn't include them in this filing, but pictures that Clara Lodema Holderman gave to my client of the family and people like that, all the things that she was sharing with her granddaughter, and I think she put on comments like, "This is your cousin," and things like that.
Letters saying who everybody was,
Yeah,
how we were related,
yeah.
who my dad was.
It's okay. It's okay. Yes. So, Your Honor, that goes to the notoriousness of Mr. Kennan accepting his paternity of Susan Davenport. So if we have an evidentiary hearing, we will bring in a whole line of people, including Stanley Cox, who used to be in the sheriff's department, who is her uncle, and tells you there is no doubt that she is John Kennan's daughter, even though the Cox family was the one who really was very upset that John Kennan was the father, because Mr. Kennan was someone who was in and out of trouble with the law and was not of the same social status as their family. But they even admit, no, he was dad. And, he was a 9-year-old in the house listening to everyone talking and everything that was said, including statements by Clara Lodema and his sister. So, Your Honor, there is a whole story here. There's a whole reason to understand that why she has every reason to be that she is John Kennan's daughter. I mean, that's what it comes down to.
Your Honor, I think we really need to, let the court know that when the mother of Ms. Davenport had the opportunity to be honest with the court, she was in the adoption case when she said father was unknown. And now we're coming here and we're trying to say that she wasn't being honest with the court, because she supposedly did know that John Kennan was the father. So, which is the truth, Your Honor? I like to go with people who, take an oath and say, hey, look, I don't know who the father is. And if she was saying and I don't know that this is true or not, Your Honor, but if she did say that to somebody that this was him, the guy who fathered her child, there's no way we're going to be able to prove that. He's deceased and she's deceased, and so we're asking for people to override the representation that the mother made, that she didn't know who the father was.
Well, on the other hand, Mr. Mills, she also didn't say that someone else was the father.
Well, Your Honor, when you say
it's just an open book, a question that has never been answered. Ms. Williams and her client believe that they can determine that there was a known father in the case.
Yes.
You're not having to rebut a representation of the mother. She just said, I'm not going to put a father's name down. I'm going to say it's unknown. The court has experience that many women do put unknown on a birth certificate, even though they in fact do know who the father is, but they take that position because they don't want that particular individual named on the birth certificate. So I see your point that that's certainly not something that helps Ms. Davenport in her claim, but also it doesn't seem, in the view of the court, to hurt her much.
Well, Your Honor,
because it doesn't establish who the father is.
if I might say, the Rickaball case tells us that we cannot base an opinion on speculation or conjecture. And that's all we will have is speculation or conjecture as to that issue.
Yeah, yet to be determined, Mr. Mills. Counsel, Mr. Weta, let me address you.
Yeah, thank you.
This court is currently contemplating sending these parties to mediation in this case to sit down with a mediator to see if there is some settlement that might be reached. Now, it would seem that the opposing parties that would need to be part of this mediation would be Mandolin Holderman and Susan Davenport. The other four aren't represented here. They haven't been actively involved in this case, even though the court has determined that they very well do have an interest. Nevertheless, they don't appear to be actively involved opposing Ms. Davenport. So rather than exhume bodies or have lengthy trials on this issue, isn't there some way, Mr. Weta, that we might be able to sit down? And of course, you would be a necessary component to the mediation because you represent the estate as a whole, and see if there isn't some way that this issue might be determined with the assistance of a mediator?
Frankly, Your Honor, I have no objection to attending a mediation with the parties. I will say, though, that frankly, it appears to me that Mandolin Holderman's position is she refuses to move off of that position. Mr. Mills has, frankly, in my opinion, filed multiple petitions out of time or out of order with the court to try and prevent Miss Williams' client from even putting on her case at a trial. And frankly, the answer to basically every single one of his questions and Miss Williams' client's questions is for us to have a trial or to exhume a body and have the DNA evidence and have the answer. So I have no problem going to mediation. I've been to mediation many times. Frankly, we will be a kind of quiet third party in that mediation. But you know, I disagree with Mr. Mills's interpretation of several of the cases, and frankly, the black letter law. And we'll be willing to share that. But for the most part, we're here as the representatives for the estate to try and just determine where we're supposed to write the checks at the end of this. And so, you know, the goal and our procedure, our goal here was to try and determine as much of this as possible through agreement before the initial petition to determine heirs was filed, during the normal process of final settlement when the court determines heirs. Obviously, that was preempted by by Mr. Mills and Miss Holderman's petition, and so we're now trying to determine that. At this point, that's fine. We still need to know who the heirs are, and my position throughout this has been we have to give each individual the ability to present their evidence that they are an heir, because even a child who is adopted out at birth has to obviously be given the opportunity to show that they are an heir, because our probate code clearly states that they should be. And so the only way for us to determine in those situations or situations that have facts like these would be, as you say, to either have a trial on the facts and determine if there is if the court believes after hearing the evidence that there is an heirship, or we need to proceed to one of the other factors. And I believe that the blood test would apply here, because again, the statute states that there are 3 different people who are there, as has been said multiple times. Children means biological children, including a posthumous child, children adopted as provided by law, and children whose parentage is or has been determined under the Kansas Parentage Act or prior law. With the Kansas Parentage Act listed separately, that can't possibly include the definition of biological children. As Mr. Mills has put forth, biological children must mean the actual biological definition of children. And in order for us to determine that, the excuse me, that was my, don't forget the kids alarm. The biological children must, the easiest way with the modern technology that we have is a DNA test at this point. And so while I would love to avoid the expense of a trial or an exhumation, if Mr. Mills's client, Miss Holderman, is not willing to accept that Miss Williams' client is indeed an heir, then I think that we have to put it to evidence, which means a trial.
All right. Thank you, Mr. Weta. Statements are appreciated. Ms. Williams, is there any room here for a compromise? Would a mediation by a trained professional be helpful to get Mandolin and your client together on perhaps resolution of financial issues or otherwise?
I don't know, Your Honor, because Ms. Holderman has seemed so intransigent on this issue, that someone she once called a cousin, now she wants her to take nothing. And so I don't know if Ms. Holderman, you have to go to mediation. For mediation to be successful, there has to be a spirit of compromise. And I'm not sure that I'm getting that from Mr. Mills and his client at this point. I will tell you, we have initiated DNA testing. My client's has been analyzed. We're still working on her great uncles. So eventually we will have actual DNA evidence, short of exhumation, but obviously exhumation is still on the table, something that can be done. We will engage in mediation if the court feels that that's an option. I'm just not sure that Mr. Mills's client is willing to go into that with the spirit of compromise that you have to have for mediation to even be possibly successful. That's my concern.
Your Honor, I'm tired of my client getting bashed all the time. The bottom line is she's asserting what I believe is the appropriate case law and providing you the case law, which we've tried to do as best as I can find it. Okay. And so as far as whether she's willing to settle this case or not settle this case, if you recall, Your Honor, you talked about that at the last hearing. And I've heard no communication from counsel or her client that they would be willing to engage in any type of settlement negotiations. The other thing that I would point out, Your Honor, is it seems a little, and I'm a little worried about this, and I truly am. We've got these four people who supposedly have an interest in this estate. We've not heard a thing from them. We've tried to contact them. Counsel has, I have, and I don't know if we even have the right address for these people, and so it concerns me that I'm sitting over here trying to negotiate something with somebody else that might impact the amount of money that they may have. So I don't think it's really almost proper for us to leave them out of the loop. When
you make a good point, Mr. Mills. Mr. Weta, do you have a handle on how to contact these four children of Esme Pearl?
We have addresses that we believe are good. None of the mail has been returned. They've chosen not to participate. But I would say based on the court's orders at the last hearing, where the court stated that they would receive, we're talking about an heirship. You don't have to enter your appearance in an estate to receive your what is due to you under the statutory provisions. And I share Mr. Mills's concern to an extent. If the settlement is anything other than an entire share for Miss Williams, or the share that Miss Williams' client is entitled to, if she is indeed Mr. Kinnon's daughter, if we get outside of those lines, it could absolutely affect the share of those four children. But in order to do that, I think the court can appoint a guardian ad litem to represent their interests in the mediation. But then we're just, again, adding additional expense to that mediation, which frankly is going to be the same thing that we would hear at trial. And so, again, I've got some concerns along those lines. And frankly, Mr. makes a good point that they are not represented in this matter. And so for us to compromise any claims, it would have to either not affect their share that they would be entitled to under the statutory provisions as the court's ordered previously, or we would have to have someone in there to represent their interests. And I frankly cannot do that. Even I have to try and treat every single beneficiary exactly the same when representing my client, the personal administrator. So.
Court currently does not have a perception that mediation might be fruitful in this case. I think the parties are too entrenched, and I do share the concern that there would be a class of beneficiaries that wouldn't be adequately represented, even with a guardian ad litem, because obviously any possible settlement could impact the amount of their interest unless Ms. Holderman were to bear, for example, the 100% out of her share of any thing that's paid to Susan. Seeing that highly unlikely that would be an agreement reached, it does not appear to the court that mediation is feasible, at least not at this time. Turning next to what I think the ultimate solution might be, Ms. Williams, I will task you with this. I need you to make an investigation of what it would cost, I want to see something in writing from who would exhume this body, what the procedure would be for gathering of the DNA, because I don't know, obviously, I don't know who would do that. Probably someone from the DNA analysis lab would have to gather the sample,
And
maybe even from the cemetery scene, which
yes,
just
Your Honor.
seems grisly to this court.
Yeah, I talked to one company who said that they could do that with a court order. Yes.
Well, okay. And then I'm going to task you with the responsibility of drafting a proposed court order to send to Mr. Weta and Mr. Mills. Now, Mr. Cranmer, you still stay involved in this, and you're certainly welcome at all times. Your clients have been determined essentially not to have an interest in this estate anymore. So your position here, Mr. Cranmer?
Thank you, Your Honor. I think that I've stayed quiet because of the ruling of the court. However, I will tell the court that my clients do want me to explore pursuing an appeal. And that may throw a wrench in any mediation, which you've already determined is probably not feasible anyway. And we still rely on the Strobel case. And I know the court's position on that. I'm not going to relitigate it. But I think the court and everybody needs to be aware that I do think my clients are going to certainly entertain an appeal.
All right.
So how that
include Mr. Cranmer in any communication then, Ms. Williams.
Okay.
As well, obviously, as the court. And I don't know in what form you intend to send this, but I need to know who's going to exhume this body, what's going to be involved, how much it's going to cost, and then how the DNA sample is going to be gathered, chain of custody, and how it would be tested.
Okay.
Obviously, the most effective DNA test would be on the decedent. In other words, the suggested father himself, Mr. Kennedy.
Okay.
He didn't leave a brother alive?
I don't know of any brothers that are alive that we have been able to find, Judge.
Okay.
Yeah. Oh, we're not positive, but as far as we know, there are none living that we know of. But you want me to basically give you a document on who can do it, how they'll do it, procedure, money, etc.
Yes.
Okay. I just want to make sure I understand. Thank you, Judge.
Yeah, and Your Honor, just for the record, and in order to potentially help Ms. Williams, I have secondhand knowledge of an exhumation that took place in a proceeding similar to this in Sedgwick County, so I can help put her in touch with the attorney who was the special administrator's attorney in that case, and help her get some of that information.
That would be helpful, Mr. Weta. Thank you.
Weta.
Your Honor, I have another procedural question, if I could ask it, Your Honor.
You may.
Since Mr. Cranmer brought up the fact that he was going to appeal, and we're going to be having this journal entry signed, is he going to have to file a motion to amend the journal entry so he can file an interlocutory appeal, because we don't have a final order? And it seems to me, if we're going through all this these gyrations. And if Mr. If Mr. Cranmer is correct on an appeal, then we're spending a bunch of time and a bunch of money that we ought not to be doing if he is correct. I disagree with his assessment. I agree with the court, but if he's going to assert that, then I think now would probably be the time to do that, as opposed to, waiting till, and I don't know if you're considering this order that you entered to be a final order as it results to Mr. Cranmer, or if you don't consider it to be a final order as it meant to Mr. Cranmer. And quite frankly, Your Honor, as to your position that the four grandchildren should take, I respectfully disagree with that, and I may want to appeal. I have to talk to my client, but I may want to appeal that on an interlocutory basis. So I'm not sure where we're at from a procedural standpoint right now.
It's a fair question, Mr. Mills. It's been the court's experience that the Kansas Court of Appeals generally disfavors piecemeal litigation and piecemeal appeals. It seems to the court, and I certainly can't make this ruling at this time, but it seems to the court that the ultimate final order in the case is the one where this court ultimately makes a determination as to the disposition of this estate. In other words, who's going to receive what share. That way, everyone's interest has been determined at that point, either favorably or unfavorably, and that appeals would naturally, if any are going to be filed, would stem from that final order. Now, if counsel sees it differently, you have to protect you and your client's own interests. But certainly that's how the court would see it. And certainly this court has specifically reserved and has not made a final determination as to the various shares of the possible claimants in this case. So
I would be willing to stipulate to what the court has just said. I just don't want to have either Mr. Cranmer or myself on the outside looking in, and somebody says, well, wait a minute, you should have filed an interlocutory appeal and you're too late, King's X, you're out. And so if everyone is agreeing that we can wait till your final order, then I guess if we'll all stipulate to that, then I guess I don't have any problem. I think it's the correct thing to do.
I think it would be a fallacy to think that we could stipulate to appellate jurisdiction.
Yeah.
Either they have it or they don't. And they make that determination ultimately as to what their jurisdiction is. Yeah. But I'm just saying that that would be my view, that until that final order is entered distributing this estate in specific shares, in other words, all of these issues have to be determined. Certainly, Ms. Davenport's issue has to be fully determined. This court's in no position to make that final order regarding disposition of the estate. And it would seem that all appeals would stem from that final order.
Okay.
But your own research would determine whether that's a proper position of the trial court or not.
Yeah.
But I understand the concern, Mr. Mill. All right. Ms. Williams, I think you know what your task is. And if you maybe confer with Mr. Wetta, it might help streamline things.
Yes.
How much time do you think it's going to take you to get that? I'm just, I want you to be realistic with me.
3 weeks, maybe.
Okay. I think that's very optimistic, and I appreciate
it. May be, Judge.
Well, I'm going to look for a review date. Counsel.
Okay, I will endeavor to get it done.
I don't want this to fall off the court's calendar. I want to review this case relatively soon with this information available, so that the court can make an appropriate determination whether that will be an order of this court. A proposed order would be very helpful to
proposed order.
This has been done before, I'm sure.
Oh, yeah.
Other cases, I would be interested in what wording of the order is appropriate for this type of unusual proceeding.
Okay.
Okay. We're looking very late November.
And then we get into Thanksgiving, Judge, so we may need to look at the beginning of December.
Friday, December 1 at 10 o'clock in the morning.
Your Honor, I have a standing obligation. Would the afternoon work for the court? I could make the afternoon work better than I could the morning.
Well, my assistant marked off that afternoon,
Oh, sorry.
so I'm sure she had good reason for doing so. Because she now tells me that I did that. So I stand corrected. If I were to set this at 1:15 in the afternoon. Oh, yes, 1:15.
Your Honor, that worked for me. This is Russell.
Joy?
That would be tight for me.
Well, I can move it back a little bit.
Oh, please, if we could go a little later in the afternoon, I would appreciate it. Thank you.
We were to set it at 3 o'clock.
Yes, that would be much better for me, Judge. Thank
All
you.
right. Halderman case will be set for review hearing by Zoom, 3 o'clock Friday, December 1. And hopefully, Ms. Williams can have all of that information, which the court had asked her to provide.
Yes, Judge.
Mediation will not be ordered at this time. And the court denies Mr. Mills' request to deny Ms. Davenport the opportunity to further pursue her claim that she is a legal heir of this estate.
Thank you, Judge.
All right. Very well. Mr. Wetta, anything further at this time?
Nothing further, Your Honor. Thank you.
Ms. Williams,
Nothing further at this time, Judge.
Mr. Cranmer,
Nothing further, Your Honor.
lastly, Mr. Mills.
No, Your Honor, nothing further.
Very well. Thank you all. If there's nothing further, then the Halderman matter will currently be in recess and this meeting may be ended for all.
Thank you, Judge.
Thank you, Your Honor.
Goodbye.